If you believe the foundations of American institutions matter, then listen closely to what comes next. Follow this channel now and activate alerts, because what unfolded today inside a Manhattan federal courtroom goes far beyond law. It became a pressure check on whether a democracy still works when someone acts as if limits don't exist. Around 11:47 a.m., during live federal proceedings, 3 of the most expensive defense lawyers in the country rose from the counsel table, collected their files, and tried to exit the courtroom while a federal judge was still speaking. Hear that clearly. Court-certified attorneys bound by oath to the Constitution attempted to leave their client behind and escape an active federal hearing because they rejected a decision. What followed is something unseen in a federal courthouse for more than 20 years. I'll walk you through exactly what happened, because every detail is critical. The session started with what observers called standard procedural debate. Prosecutors were requesting permission to introduce specific financial records. The defense objected as expected. Nothing unusual for a case this complicated. But the background is essential. 48 hours before this hearing, an event occurred that only came to light because of a mistake. A sealed motion was mistakenly posted to PSR, the federal court's electronic system. It remained public for exactly 17 minutes before being pulled. During that brief window, legal analysts downloaded it. What was inside? According to several individuals who examined the material, prosecutors introduced newly obtained evidence showing encrypted messages between Trump and his co-defendants during a period the defense had repeatedly described as a total communication blackout. The filing also reportedly detailed wire transfers totaling $4.7 million and included what one reviewer called the most severe documentary trail ever seen in a white-collar prosecution. Earlier today, Judge Patricia Caldwell ruled that all 847 pages would be admitted. That decision triggered the collapse. Lead counsel Robert Sterling stood up from the counsel table. Court reporter Maria Rodriguez recorded every statement. Sterling said, "Your Honor, this court has discarded any claim of neutrality. We will not take part in what is now a scripted outcome." Co-counsel Jennifer Matthews followed, saying, "This represents extreme prosecutorial abuse, and we decline to validate it by staying." Then they moved toward the exit. Now, understand this about federal courts. Judge Patricia Caldwell was appointed under Reagan. She has spent 31 years on the bench. She is widely respected for calm judgment. Defense lawyers usually welcome her courtroom because it is considered balanced. She watched 3 attorneys attempt to leave their client in the middle of trial and stated words now preserved in the record. "Counsel, take another step and I will find you in criminal contempt and issue warrants for your arrest." She then instructed U.S. Marshals to seal every doorway. 6 federal marshals with weapons were at every exit almost instantly. The confrontation lasted 7 minutes and 23 seconds. If this breakdown is helping you understand what's unfolding, tap like now, because the situation is about to take a sharp turn. Here's what Judge Caldwell disclosed that explains why Trump's lawyers were so eager to get out. According to people with first-hand knowledge, the judge stated she had received a sealed ex parte filing from the Justice Department earlier that morning. For anyone unfamiliar with court practice, this is critical. Ex parte means only one side is allowed to see the submission. Federal judges almost never permit this. It is typically limited to cases involving national security risks or endangered witnesses. On the record, Judge Caldwell said that based on the filing, she was weighing additional security steps and the possible sequestration of the jury. Every seasoned defense attorney immediately grasped the message. The government has a cooperating witness. Someone close to Trump has broken ranks, former federal prosecutor Andrew McCarthy said on Fox News hours later. When defense lawyers hear about a sealed ex parte filing in a case this large, they know the pressure just skyrocketed. Someone inside has flipped, and something explosive is coming that the defense didn't anticipate. The reaction suddenly adds up. Now let's connect the dots, because this is where it shifts from courtroom spectacle to something much bigger. Records show that within 30 minutes of sitting back down after the 7-minute standoff, Sterling's team submitted an emergency mistrial request accusing the court of bias and the prosecution of misconduct. At the same time, they moved to disqualify Judge Caldwell, claiming her warning constituted personal hostility toward the defense. Notice the pattern. By staging this confrontation, they created a foundation for future appeals. No matter how this case concludes, analysts across the legal spectrum agree on one thing. This was performance aimed well beyond the courtroom walls. And there's evidence it was planned. Sources say Fox News crews were already stationed outside the courthouse 45 minutes before the attempted walkout. Several conservative voices were posting about judicial overreach before the incident was publicly reported. How did they know something was coming? Subscribe if you want to track what happens next, because the stakes are enormous. That sealed ex parte filing Judge Caldwell referenced. Justice Department officials say it relates to testimony scheduled for next Tuesday from an individual identified only as Witness 14. This person is said to have direct knowledge of the financial dealings at the heart of the government's case. This person has reportedly been under protective custody since October. The defense team's attempted exit happened exactly 96 hours before that testimony is set to begin. Accidental. The timing speaks for itself. Legal experts are already debating the identity of Witness 14. The prevailing view points to someone deep inside Trump's financial operation, possibly a chief financial officer or senior controller with first-hand access to the disputed transactions. Protective custody starting in October signals serious danger. That level of security is usually reserved for organized crime cases or matters touching national security. If this witness delivers what prosecutors expect, the damage to the defense could be devastating. After the standoff ended and the attorneys retook their seats, Judge Caldwell issued a statement that sent shockwaves through legal circles. In light of counsel's attempted withdrawal during trial, she said, "The court is considering appointing shadow counsel to safeguard the defendant's Sixth Amendment rights." Shadow counsel means court-appointed backup lawyers sitting beside the defense, prepared to step in immediately if the current team tries to leave. It's the courtroom version of understudies, except the consequences involve liberty and the credibility of the American justice system. The financial fallout is already surfacing. According to FAHE records, Sterling's firm has billed more than $12 million in fees. Late Friday night, Bloomberg reported the firm had entered urgent discussions with its malpractice insurer. Sources say the insurer is worried about exposure if the walkout attempt results in a mistrial or a successful appeal. Industry observers suggest coverage itself could be jeopardized, potentially placing partners' personal assets at risk. That may explain why senior partners were seen arriving at the firm's Manhattan offices around 10 p.m. Friday for what insiders described as an emergency crisis meeting. Press like if you recognize why this extends beyond one defendant. What unfolded today threatens something much larger than a single verdict. If lawyers can abandon trials whenever rulings displease them, the entire judicial framework breaks down. Judge Caldwell appeared fully aware of that danger when she stated, "This court will not allow counsel to manipulate proceedings through deliberate disruption. If rewarded, such conduct would invite every losing party to engineer a mistrial by walking away." She's right. Once that precedent exists, any defendant facing conviction could order their lawyers to storm out and claim injustice. In modern federal history, only 3 similar attempts exist. In 1978, mob attorney tried leaving during the Sano Trafficante trial and faced disbarment threats. In 1992, during the BCCI banking scandal, 2 defense lawyers attempted withdrawal and were compelled to continue under contempt warnings. In 2009, Bernie Madoff's original defense team attempted to quit just 2 days into testimony and were ordered to remain. In every one of those 3 cases, the defendants were later convicted. In every case, the lawyers suffered serious professional consequences. The pattern isn't subtle. The political reaction was instant. Minutes after the attempted walkout, Trump posted on Truth Social, "My lawyers are fighters who refuse to tolerate this rigged trial. Judge threatening arrest. Election interference." The post crossed 2.3 million views within an hour. Republican lawmakers responded quickly. Senator Tom Cotton wrote, "When judges threaten to jail lawyers for defending clients, we're in banana republic territory." Senator Elizabeth Warren responded, "No one is above the law, including lawyers who attempt to derail court proceedings." But here's what stands out. A Reader's Ipsos Snap poll conducted Friday night showed 67% of Americans disapproved of the lawyers' actions, including 48% of Republicans. 72% agreed that no one, including former presidents, should be above the law. Even longtime allies are uneasy. Alan Dershowitz told Newsmax, "Walking out on a federal judge is indefensible. There are lawful ways to raise objections. Abandoning your client during trial is not one of them. When Alan Dershowitz won't back you, a rarely crossed boundary has been breached." Now consider a detail few have reported. A defense paralegal speaking anonymously said Robert Sterling received a text at 11:42 a.m., 5 minutes before the walkout. The message read only "Abort Mission." The source claims it came from a senior Republican strategist involved in messaging strategy. If accurate, this suggests the scene was engineered for political impact, not legal necessity. Judge Caldwell appears to share that concern. In a written order issued Friday night, she included this language. "The court has reason to believe elements of today's conduct were coordinated with outside actors for purposes unrelated to justice. Any further effort to convert these proceedings into political theater will trigger the full scope of sanctions, including contempt, monetary penalties, and referral to bar authorities." A federal judge is now on record stating she believes the disruption was staged political theater. Absorb that. Following the morning's turmoil, the U.S. Marshals Service raised courthouse security to maximum level. Extra metal detectors were installed. All entrants faced heightened screening. NYPD added perimeter units. The FBI's New York field office reportedly placed agents on standby. This is far from routine. During the afternoon session, a note reached Judge Caldwell, triggering an immediate sidebar. Sources say court security had identified several individuals connected to far-right militia groups near the courthouse. No specific threat was confirmed, but their presence added a tense new layer to an already volatile day. The judge reportedly warned both sides that any attempt to incite public disorder would be met with the full weight of federal law enforcement. The fallout isn't confined to the U.S. European legal experts reacted with disbelief. The UK's former director of public prosecution said, "In any common law system, this conduct would lead to immediate detention." French media ran headlines translating roughly to "American justice in chaos as Trump lawyers defy judge." Russian state outlets predictably seized the story as proof of U.S. institutional weakness. The fact these attorneys felt emboldened to attempt such a stunt highlights a serious erosion of respect for judicial authority, with consequences far beyond this single trial. If you're still watching, subscribe, because the next part is the most critical. Sources close to Trump's inner circle say there are active discussions about replacing the entire legal team. Names being considered include some of the most controversial lawyers in the country, defense attorneys who have represented war criminals and terrorism suspects. The apparent strategy: if we're going down swinging. This puts Judge Caldwell in a nearly impossible bind. If she allows Sterling's team to withdraw, the trial could be delayed for months while new lawyers get up to speed. If she forces them to continue against their will, she opens the door to appeals over ineffective assistance of counsel. One former Supreme Court clerk called the situation brilliantly cynical. The defense has crafted a scenario in which the judge has no good options. Meanwhile, sources say prosecutors are preparing what's being court nuclear option, asking the court to revoke Trump's bail based on his lawyer's behavior. Anyone whose legal team tries this kind of disruption is a flight risk and threatens the orderly administration of justice. Even if it fails, attempting this move would dominate headlines and shape public perception of the trial. Consider the pressure this puts on the 12 jurors who will ultimately decide the case. While the jury wasn't present during the walkout, the tension in the afternoon session was palpable. Juror 7, a retired Brooklyn teacher, was seen shaking her head repeatedly during defense arguments. Juror 3, a small business owner, took meticulous notes whenever the judge spoke to the defense. Jury consultant Dr. Patricia Williams told CNN, "When jurors see this level of conflict between a judge and defense attorneys, they often read it as a sign of guilt. Why would lawyers risk everything unless their client was in serious trouble? The defense may have scored procedural wins today, but they may have lost the jury's trust." Monday morning, Judge Caldwell will rule on the defense team's motions for mistrial and recusal and decide whether witness 14 will testify as scheduled. She has made clear that any further disruptions will lead to immediate arrest. U.S. Marshals have reportedly been briefed on arrest procedures for attorneys, a step sources say hasn't happened in living memory. Timing matters. With just 11 months until the 2024 election, each day this trial continues is a day Trump cannot fully campaign. Some analysts suggest the walkout was designed to force a mistrial and delay any retrial past the election, a high-risk, high-reward political gambit disguised as courtroom maneuvering. Judge Caldwell appears resolute against that. Sources familiar with her thinking say she's willing to hold sessions 6 days a week to keep the trial on schedule. She's also reportedly considering restricting media access if coverage is fueling theatrical behavior. What happened today wasn't merely legal strategy. It was an effort to turn an American courtroom into political theater. When lawyers feel free to walk out on federal judges without consequence, when defendants treat criminal trials like campaign events, when justice starts to feel like reality TV, we have crossed a line our constitutional system may not be prepared to manage. Even Republicans are distancing themselves. Senator Mitt Romney said, "Respect for our judicial system is fundamental to democracy. Everyone deserves zealous representation, but attempting to flee a federal courtroom crosses every line." Even Senator Josh Hawley, normally a staunch Trump supporter, emphasized that attorneys must follow proper procedures. When you start losing the Josh Hawleys of the world, your legal strategy has serious flaws. The real consequences here extend far beyond any single verdict. Every American deserves skilled lawyers and a fair day in court within clear, established rules. When those rules collapse, when attorneys literally try to run out instead of facing unfavorable rulings, it shows that our system can be manipulated by anyone with enough money and nerve. That's not justice. That's chaos in a suit, billed by the hour. The stakes go far beyond this one trial or defendant. If Trump's team succeeds in turning criminal proceedings into political theater, every wealthy defendant will be tempted to do the same. Picture trials where any well-funded defendant can order their lawyers to walk out when a ruling doesn't suit them, where court sessions are designed for social media performance rather than truth, where judges must threaten arrest just to keep basic order. That is not a justice system. It is the collapse of the rule of law itself. The key questions now: can Judge Caldwell restore order? Will Trump's legal team continue to disrupt? Can the judicial system survive this unprecedented attack on its principles? Make sure you're subscribed with notifications on, because this story is far from over. When Witness 14 testifies, when the judge rules on the mistrial motion, when we finally learn who sent that abort mission text, you'll want to know immediately. Hit like. Leave a comment with your thoughts on what happens next. Share this video with anyone who cares whether American democracy can survive this. This is no longer about one trial or one defendant. It's about whether we truly, effectively believe that no one in this country, no matter their wealth, power, or connections, is above the law. The answer will shape America for generations. I'll see you Monday when the judge delivers her ruling.